Good evening, Dean. Good evening, classmates. I am Irish Camomot, and as a continuation, let's now proceed to section 2, effects of guarantee between the debtor and the guarantor. Article 2066, the guarantor who pays for a debtor must be indemnified by the latter. So since the debtor is the one directly and principally liable, it is just that the guarantor who makes payment must be indemnified by the debtor. So the indemnity comprises of the following. We have the total amount of the debt, the legal interest thereon from the time the payment was made known to the debtor, even though it did not earn interest for the creditor, the expenses incurred by the guarantor after having notified the debtor that payment had been demanded of him, and the last but not the least, the damages if they are due. So here are the indemnity comprises. So let's take it one by one. First, we have the total amount of the debt. So the total amount of the debt includes interest paid by the guarantor. The guarantor has no right to demand reimbursement until he has actually paid the debt, unless by the terms of the contract, he is given the right before making payment. And also, he cannot collect more than what he has paid. So let's take a look of the case of Tuazon versus Machuca. So the facts of the case, G Company signed a note for 10,000 in favor of C Company to guarantee a liability of D Company to C. In turn, D and its president, E, the latter in his personal capacity, executed a document wherein they bound themselves solidarily to reimburse G all such sums as G may pay or become bound to pay upon its obligation to C, whether or not it shall have actually paid such sums or any part thereof. D was declared insolvent. C brought action against G to recover the value of the note and obtain final judgment. Later, G filed a complaint against E to recover the amount which G was sentenced to pay C, plus attorney's fees, judicial costs, and sheriff's fees and interest, although G had not in fact paid the amount of the judgment. So the issue in this case is G entitled to the relief suit in view of the above facts. The court held in affirmative. It is indisputable that D became bound by virtue of the final judgment to pay the value of the note executed by it in favor of C. And according to the document executed solidarily by D and E bound himself to pay G as soon as the latter may have become bound and liable, whether or not it shall have actually paid. So the second indemnity, we have the legal interest thereon. So the guarantor is entitled to legal interest from the time the notice of payment of the debt was made known to the debtor. The notice is in effect a demand so that if the debtor does not pay immediately, he incurs in delay and hence renders him liable for legal interest as indemnity from then on. Also, the liability is increased not because of the contract, but because of the default and the necessity of judicial collection. The third one, we have the expenses incurred by the guarantor. So the expenses referred to are only those that the guarantor has to satisfy in accordance with law as a consequence of the guarantee. These expenses are limited to those incurred by the guarantor after having notified the debtor that payment has been demanded of him by the creditor. And the debtor is to blame for said expenses, for it is within him to free himself from the responsibility by making payment. And if he does not do so, then they are attributable to his fault. So with the same case of Tuazon versus Machuca, the debtor is being held liable by guarantor for expense incurred by the latter in litigation between him and creditor. So having the same facts, we have the issue is, has G the right to recover from E more than the value of the note executed by G in favor of C? The court held that E must not be held responsible for the expenses incurred by G in the litigation between it and C. that litigation was originated by G having failed to fulfill its obligation with C and it cannot charge E with the expenses it was compelled to make by reason of its own fault. It is entitled, however, to the expenses incurred by it in the action brought by it against E. Interest on 10,000, the value of the note which it was sentenced to pay, from the date of the filing of the complaint until full payment thereof, plus attorney's fees. So the last indemnities, we have damages if they are due. So the guarantor is entitled to recover damages only if they are due in accordance with law. The Civil Code has established no norm for determining the same. Thus, the general rules on damages shall apply. Note also that the damage suffered by the guarantor with respect to the payment of money to the creditor is compensated by the payment of the legal interest to the guarantor. As we all know, in every rule, there's always an exception. So here are the exceptions to right to indemnity or reimbursement. So first is where the guarantee is constituted without the knowledge or against the will of the principal debtor. The guarantor can recover only insofar as the payment had been beneficial to the debtor. The second one is if payment by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which however requires the debtor's consent, but the payment is in case valid as to the creditor who has accepted it. And the last one, we have the right to demand reimbursement is subject to waiver. Now let's proceed to Article 2067. The guarantor who pays is subrogated by virtue thereof to all the rights which the creditor had against the debtor. If the guarantor has compromised with the creditor, he cannot demand of the debtor more than what he has really paid. The guarantor's right to subrogation. So, what is the effect of subrogation? Subrogation transfers to the person subrogated the credit with all the rights thereto appertaining either against the debtor or against third persons, be they guarantors or possessors of mortgages, subject to stipulation and conventional subrogation, except only for the change in the person of the creditor by the guarantor, the obligation subsists as before payment. When, besides the guarantee, the principal debtor's obligation is secured by a pledge, mortgage, or other security, the guarantor is also subrogated to all the rights. The rights to indemnification and subrogation established and granted to the guarantor by Article 2066 and 2067 extend as well to sureties as defined under Article 2047. We also have accrual basis and nature of right. So this right of subrogation is necessary to enable the guarantor to enforce the indemnity given in Article 2066. It arises by operation of law upon payment by the guarantor. The right of the guarantor has paid a debt to subrogation stands not upon contract but upon the principles of natural justice. The right of subrogation is not a contractual right. If the guarantor paid a smaller amount to the creditor by virtue of a compromise, he cannot demand more than he actually paid. When right not available. So the benefit of subrogation is the means of effectuating the right of the guarantor to indemnity or reimbursement. It cannot therefore be invoked in those cases where the guarantor has no right to be reimbursed. Payment against the will of the debtor. Under Article 1237, whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. Partial payment. Under Article 1304, a creditor to whom partial payment has been made may exercise his right for the remainder, and he shall be preferred to the person who has been subrogated in his place in virtue of the partial payment of the same credit. So now let's have the case of which illustrates the guarantor seeks reimbursement for 20,000, the amount of the bond executed by sub-guarantors, notwithstanding that he paid only 8,000 of his bond. So the facts of the case, by order of the court, X, as judicial administrator of an estate, gave a bond to guarantee his administration. The judicial bond was executed by X, G, and others jointly and severally in favor of the government for the sum of 60,000. In turn, X and 5 others executed in favor of G another bond as follows: A for 20,000 and B, C, D, and E for 5,000 each to guarantee the reimbursement of whatever amounts which G might be required to pay by reason of the judicial bond aforementioned. So as guarantor in solidum of X, who was replaced by H as the new administrator, G was ordered by the court to pay to the estate the sum of 48,000. G paid to H 8,000. G is still owing 40,000 plus interest. X could not pay G. In the suit instituted by G against X, A, B, C, D, and E, the lower court absolved A from the claim by reason of the fact that the share of the bond concerning him was executed by an attorney in fact without sufficient authority for the purpose, and ordered B, C, D, and E to pay G the sum of 2,000 each and in equal shares the cost. Thus, B, C, D, and E would be paying the proportional share 4,000 or 1,000 each of A in the 8,000 paid by G as well as A's part of the cost. So the issue now is, should B, C, D, and E reimburse G 5,000 each, or a total of 20,000, notwithstanding that G had paid only 8,000 of his bond? The court ruled in negative. Guarantor's right of reimbursement limited to amount paid. So the right of subrogation cannot be interpreted in such absolute terms as to include more than the surety or the guarantor has paid. For though it is true that he puts himself in the place of the creditor and should have the same rights as the latter in consequence of the subrogation, it is no less certain that there would be an unjust enrichment to the prejudice of the debtor if the surety who pays for him were permitted to claim more than what he paid. Now let's proceed to Article 2068. If the guarantor should pay without notifying the debtor, the latter may enforce against him all the defenses which he could have set up against the creditor at the time the payment was made. So, effect of payment by guarantor without notice to debtor. So, Article 2068 assumes that the guarantor may pay the creditor without any notification to the debtor. However, if the guarantor should pay without notifying the debtor, the latter may interpose against the guarantor those defenses which he could have set up against the creditor at the time the payment was made. Thus, if the debtor has paid the creditor when the guarantor pays, the debtor can set up against the guarantor the defense of previous extinguishment of the obligation by payment. The guarantor cannot be allowed through his own fault or negligence to prejudice or impair the rights or interests of the debtor. Article 2069. If the debt was for a period and the guarantor paid it before it became due, he cannot demand reimbursement of the debtor until the expiration of the period, unless the payment has been ratified by the debtor. So the effect of payment by guarantor before or after maturity. So if the debtor's obligation is with a period, it becomes demandable only when the day fixed comes. So the guarantor who pays before maturity is not entitled to reimbursement, since there is no necessity for accelerating payment. A contract of guarantee being subsidiary in character, the guarantor is not liable for the debt before it becomes due. Where demand on the guarantor was made during the term of the guarantee, the fact that payment was actually made after said term is not material. What is controlling is that default and demand on guarantor had taken place while the guarantee was still in force. Now, let's proceed to Article 2070. If the guarantor has paid without notifying the debtor and the latter not being aware of the payment, repeats the payment, the former has no remedy whatever against the debtor, but only against the creditor. Nevertheless, in case of a gratuitous guarantee, if the guarantor was prevented by a fortuitous event from advising the debtor of the payment, and the creditor becomes insolvent, the debtor shall reimburse the guarantor for the amount paid. So the effect of payment by the debtor, effect of repeat payment by the debtor. So as a general rule, before the guarantor pays the creditor, he must first notify the debtor. If he fails to give such notice and the debtor repeats the payment, the guarantor's only remedy is to collect from the creditor. But he has no cause of action against the debtor for the return of the amount paid by him, even if the creditor should become insolvent. But there are also exceptions. So the guarantor may still claim reimbursement from the debtor despite lack of notice if these conditions are present. So first, if the creditor becomes insolvent. And second one, if the guarantor was prevented by fortuitous event to advise the debtor of the payment. And the last one, if the guarantee is gratuitous. So in a gratuitous guarantee, the guarantor receives nothing. And it would be unfair to deny him the right to recover from the principal debtor. So if the creditor is solvent, the guarantor must still recover from him. That's all for my report. Thank you for listening.